So an interesting case they reported this week. A High Court has cancelled the award of €20,000 awarded by the RTB, the Residential Tenancies Board, to tenants who alleged that they lived in damp and mouldy conditions in an apartment. Landlords are not required to press building management companies to perform contractual repair obligations, the judge has found. So to summarise, the RTB granted an award of 20 grand. The High Court has cancelled this award. The situation is the family of 5 alleged significant damp and mould in their central Dublin apartment exposed them to health issues. The judge found that a Residential Tenancies Board appeals tribunal made legal errors in its handling of a complaint by the Sorocas against their landlord to a housing association. This is one of the largest non-profit rental bodies of offering affordable lets to people who cannot afford private rentals. He said that the tribunal incorrectly assumed Tua owed the couple some sort of duty to pursue the management company of the apartment block over structural defects that were causing water ingress in the duplex apartment. The tribunal must apply the law as set out in the tenancy contract and legislation relating to a landlord's repair obligations, he said. In this case, he said that the RTB omitted to decide an issue which it was required to decide and proceeded to decide something else. He cancelled the decision and award, and he returned the Sorocas' complaint for fresh consideration by the RTB, the Residential Tenancies Board. These people, the Sorocas, paid €129 a week in rent. They complained to the RTB alleging that there were leaks in their duplex apartment in Dublin's Grand Canal dock area since they moved in 2006. They and their 3 children were constantly around mould and damp, which they submitted exposed them to various breathing and other health conditions. Tua, the housing association, told the tribunal that it owned 60 of the 290 apartments in the Gallery Quay development, which has had ongoing issues since 2009. It said that the Sorocas' apartment was not up to the standard and needed work. It carried out remediation works, but it said structural and other repairs were the responsibility of the building management firm, Gallery Quay Management Company. It said that it recently offered the family a 3-bed property nearby, but this was declined. The Sorocas told the tribunal the alternative accommodation offered by Tua was not in a suitable location or was not the right size for their family. In its ruling on the dispute last year, the tribunal noted that there was a 2021 settlement of a court case between the management company and its insurers over building defects. At the time of the hearing, repairs to prevent the rainwater ingress into the building fabric had not occurred. The tribunal held that Tua, as the biggest property owner in the building, could have undertaken works sooner or forced the management company to do the repairs. It awarded the Sorocas €20,000 after finding there was a landlord breach of maintenance at the most serious level given the length of time that it persisted. Tua Housing Association appealed this to the High Court, asking to what extent a landlord can avoid futile repairs where the damage is caused by defects in other parts of the building for which it is not responsible. The judge said that a landlord's maintenance obligations under the 2004 Residential Tenancies Act are confined to repair to the structure of the dwelling. So instead of considering how this obligation applies to an apartment in a block, the RTB tribunal decided that Tua was obliged to pursue the management company on behalf of its tenants. The judge said that the 2004 Act does not oblige landlords to press management companies of multi-dwelling buildings to perform their contractual duties to repair structures or other elements. Landlords are also not required to sue developers, builders or architects who may be responsible for faulty design or construction. He said that it would be impossible to imply such a vague duty into a tenancy agreement. And in this particular case, remember, we're talking about an apartment in an apartment block, and ordinarily an apartment involves a cube of space. In other words, the building itself, the fabric of the building, is usually the responsibility of the management company. And for that reason, the judge held that it would be unreasonable to hold Tua, who owns, remember, the apartment and the cube of space, not the building itself. It would be impossible, or it would be unfair to imply or infer an obligation on the housing association, the owner of the apartment, to repair the building itself, or to compel the Tua to pursue the management company. I hope you find this video useful. If you do, I'd appreciate if you hit the thumbs up button down below, and you may be interested in subscribing to my YouTube channel. If you are, just hit the subscribe button. Thank you very much.